So we are here to discuss the idea of new tools in competition law. This is today a fashionable topic because Mario Draghi, in his famous report to the European Commission, is suggesting to provide a new tool to the European Commission. And in many countries, you see parliaments granting new tools to their competition authorities. And Alessia, I understand that a few days ago, the Italian parliament voted for providing a new tool to the Autorità Garante della Concorrenza. So it's fashionable, it's also paradoxical, because a few years ago, I think it was in 2020, the European Commission launched a public consultation on whether a new tool was necessary or would be necessary. And this new tool was more or less the same that Mario Draghi is suggesting. The ability to conduct market investigation, to detect dysfunctioning markets, and then the ability to find, to discuss, and maybe to impose solutions on the market, on the companies, without the need to find any infringement. This is a new, or it would be a new tool, because most competition authorities, as you know, have three traditional tools: prosecuting anti-competitive agreements, abuse of dominance, and controlling mergers. The two first are ex-post tools. The third is an ex-ante tool, but the three share a common feature. It's not the existence of an economic problem in a market that triggers the intervention of the authority. Is the fact that some company is doing something, entering into an agreement, abusing its market position, or deciding to acquire a target. So the triggering event is not an economic problem, it's a behavior by a company. So it's really something new, and it's of course interesting to see that a number of national authorities are now using these tools. But of course we could wonder why a few years ago, after its public consultation, the European Commission decided not to go ahead. It means that there are probably downsides. And indeed, the public consultation was not very positive. I mean, the majority of respondents were against this idea. Even national competition authorities were generally against this idea. So, benefits, because of course that would help the Commission to deal with problematic situations and to deal maybe in time, because that's a traditional critic about the old tools, that they take a lot of time and they need a lot of legal strength, otherwise they can be quashed by the courts. Indeed, the European Commission had, in his public consultation, identified two situations where they could be very useful: market with a possible tipping point. It would be useful to intervene before it is too late, or market with high barrier to entry, which are not the fruits of behavior of anybody, but they are there, and maybe something should be done. And so to address this question, whether the European Commission needs new tools, we have three distinguished panelists. Alessia Marazzo is a bright economist with SLIR, and she will explain whether there is indeed under-enforcement, under-control of economic dysfunctional situations, taking also practical examples. Stefan Sagebro is the head of competition with the Confederation of Swedish Enterprises, so he will bring the point of view of companies and also a point of view coming from Nordic countries, where there are already some countries with existing new tools, and other one which is considering adopting tools. And last but not least, of course, Lars Mesenbrick, who is a partner with Orrick in Germany. And Germany is, of course, the largest economy in the EU, but also one of the first, I think, which adopted this kind of new tools a few years ago. So you have some experience now that you could share with us. Alessia, I let you the floor.
Thank you, Patrick. Good afternoon, everyone, and I hope you are enjoying these days at the festival. And thank you, Patrick, for having invited me again at your session. I think this year, as last year, we have a very fashionable topic, as you said, to explore. And I will start addressing your question with the CMA experience because I believe that will give us some valuable context for our discussion. As you said, the new competition tool is an attempt to target markets where competition is not working properly and for reasons other than just the conduct of the undertakings, but for structural markets of the features of the markets. So the overall idea is to provide competition authority with the ability to intervene with the structural and behavioral remedies where traditional tools cannot be applied because there has not been an infringement of competition law, but still the market suffers from a structural lack of competition. So I wanted to start this discussion by exploring which could be the causes of this structural lack of competition, and I will draw from the UK experience. The new competition tool indeed can hardly be described as new in UK. The Competition and Markets Authority and before the Office of Fair Trading and the Competition Commission were vested with such market investigation powers with the Enterprise Act in 2002, and since 2002 the CMA conducted 20 market investigations, and I have selected 3 examples that I think clearly illustrate the practical application of this tool. So let me start with the first one, that is an investigation in the market for funeral services conducted in 2020. The CMA observed annual price increases well in excess of inflation for over 13 years, which were not explained by the cost. There were no anti-competitive agreements, no dominant players which could have suggested an abuse of dominance, but still there was a lack of competition. And this lack of competition was explained by the low level of customer engagement when purchasing the funeral, maybe explained by the challenging circumstances in which this purchase generally happen. The CMA imposed behavioral remedies, and the idea was to have price transparency. So basically, among other measures, the remedies included an obligation for all funeral directors to disclose prices in a manner that help consumers to make more informed decisions. The second example is an investigation in the market for air transport. It's a bit old, from 2009. The British Airports Authority at the time owned several airports in the southeast of England and in Scotland. And the Competition Commission concluded that the common ownership precluded effective competition because it was discouraging investment and there was indeed a shortage of capacity. The Competition Commission required structural remedies, so the divestiture of some airports, in 2 airports actually, in southeast England and 1 in Scotland. The third and final example is the investigation in the market for retail banking conducted in 2016. At that time, the CMA investigated the supply of personal current account and of the supply of banking services to small and medium-sized enterprises. Now, again, there was no anti-competitive agreement, no dominance, but still there was a structural lack of competition. And indeed, the CMA identified persistent concentration, high barriers to entry, which were related to the informational advantages of the largest bank, and low customer engagement, which was demonstrated by the fact that there was a low level of searching and switching. So customers were not posing a threat of switching to the largest bank. This was leading to worse outcome for consumer. Again, the CMA intervened with some remedies, some behavioral remedies. One of these was really innovative at the time because it was the open banking standard, and which was introduced at a time in which fintech and mobile banking tools were just emerging. And the idea of the CMA was to require largest retail banks to develop and adopt an application program interface standard so that banks can share under the consent of their customer, of course, they can share information on transaction data of their customer with other banks and with other intermediaries. And this is revolutionary if you think about it, because it basically would allow us to have in a single digital app the possibility to manage account with multiple providers, or to have have control of our funds. And it also allow us to compare products based on our products offered by different providers, based on our own requirement, based on our transaction data. So I think that these three examples show that there are some market features that can prevent markets to work properly, to self-correct. So the funeral service investigation provides a clear example of how consumer behavioral bias can prevent competition. The retail banking investigation also has a consumer component, but also illustrates how factors such as asymmetric information, high switching cost, economies of scale can hinder competition. And these are market features which are not caused by firms' conducts. They can be exacerbated by firms' conduct, but they are not caused by firms' conduct. And then I think the example of the British Airports Authority is also very interesting, because there are also some firms' conduct that could lead to worsen outcome to consumer and cannot be captured by traditional tools, such as common ownership, and that was the example of British Airports, the authority, and tacit collusion and algorithmic collusion. So I think now the question is why all the national competition authorities are looking at this new competition tool, or many national competition authorities are looking at this tool. We have been discussing a lot during the plenary session this morning that there are new market trends that are emerging. There is an increase in the level of industry concentration, in the level of markups. There is a slowdown in business dynamism. And I think that the bottom line of the discussion that we had this morning is that the shape of competition is changing, because the economy is shifting towards more innovation-heavy sector, where innovation is critical to compete. And in these markets, features like high fixed cost, data and network effects, winner takes all or take most character, all these features are more likely, and it is more likely that these markets become characterized by one or two large companies or platforms. So basically this means that the situation where the traditional tools are not enough are becoming more common. So, and this does not happen. This does not only happen in the digital markets. So, to sum it up, if the question is whether there are situations where competition is lacking and the current tools cannot step in, I think the answer is yes. But then if the question becomes whether we should give competition authority new, flexible, very broad competition tool to intervene in this situation, I think the answer is more complex. And I think that Lars and Stefan will help us to shed more light on this, so I will stop here for now.
Thank you, Alessia. Stefan, are you convinced by the necessity of creating such tools?
Thank you very much for giving me the floor and for having me here, and also to the organizers. And I will have a presentation, and then we'll see if you can see the presentation and the text. Let's hope so. Here it comes. I think I will stand up, if that's okay, and talk a bit. So hi everyone, Stefan Sagerbro from the, the clicker, from the Confederation of Swedish Enterprise, which is sort of the main business organization in Sweden. We have most of the big Swedish, probably well-known companies as our members, but most of our members are actually SMEs, 98%, in total 60,000 companies. So I will talk a little bit about the inquiry that is going on in Sweden, because also in Sweden the government is pondering whether this should be included or not. And I will give some insights from that from a business perspective. So first of all, as you said initially, Fredrik, things are moving quite fast, so fast that I even have an outdated slide here. As you can see, Italy should have been colored red on this slide because Italy already has this tool. It flew below my radar. It was an airplane joke, sort of. It started in the airplane sector and then apparently it became a general tool. These countries which are colored red, you can see here, are the EU countries which have this kind of tool. UK was, as you said, the first one and sort of the go-to country to look at. And just recently we've had both Germany and Denmark, and in Norway a bill has been passed to the parliament, which probably will vote that through and will enter into force maybe 24 or maybe rather 2025. And in Sweden, as I said, there's an ongoing public inquiry looking into this. Is this a necessary thing? And well, first of all, competition plays a fundamental role for growth and innovation. I think we all agree on that. This is also sort of the baseline for this task for the inquiry. And then there's a problem described in this task for the inquiry to look at. And as you said, Alessia, there are several problems that this kind of tool could tackle. What is mentioned here is mainly the fact that we've had high inflation during the last couple of years. This is sort of the political argument why action is needed, sort of, and why the politicians need to show that they are sort of have strength and are acting. But also based on the fact that in Sweden, at least, and maybe in other countries, there have been sectoral reports from competition authorities in different sectors calling for different regulatory changes to improve competition and lower the entry, making it easy to enter the markets, and so on and so forth. Maybe not everything that has been called for by the competition authorities have been made a reality by the government. But also the fact that there is a current trend in introducing such new tools that has been actually mentioned in this assignment for this inquiry, that, for instance, Germany recently have introduced this. So, and also the fact that there could be a regulatory gap, that broader structural competition problems are difficult to deal with. So, this is what the inquiry in Sweden are looking into right now. It's supposed to be finished and present its results by February next year. So we'll see what will happen. And I am in the expert group, so I have some insights at least. I just want to mention very briefly 2 other tasks for this inquiry, which might be interesting for you competition nerds. They are also looking into whether there should be a possibility for the competition authority to oblige certain companies in sectors where there are competition problems to inform about also non-notifiable mergers. So you can see in the slide we have 2 thresholds, turnover thresholds in Sweden, but the competition authority can require a notification in certain cases, even if only the first threshold has been reached. The typical, you know, what's it called? The killer acquisition situation, sort of. And we'll see what the inquiry will come out in that case. The other thing is specific rules that we have in Sweden regarding anti-competitive public sales activities from municipalities, for instance, where we have specific rules trying to limit the extent to which public entities can sell things on the market. So this is something that the inquiry will look into, and if this is interesting for you, please contact me and I can describe more about this. Now to the tool to be presented, and as I said, this is an ongoing inquiry, but much is already sort of put on paper. And then we'll see, of course, if the government will push through, but this is more or less what the inquiry will present, a horizontal tool, not limited to specific sectors, where the Swedish Competition Authority can impose both behavior and structural remedies, measures rather, towards one or several sectors on the market. And currently there is no specific threshold described. I mean, in other jurisdictions it's pronounced as if there should be maybe structural problems of a certain magnitude, for instance, but no such thing is proposed here by the inquiry. And the gathering of information can be done in many ways. It can come from, merger cases or a dawn raid or some tips coming into the authority. So they can base their information on whatever they like, sort of, and then make a decision to initiate an investigation. But the investigation is more about what kind of remedies should be suitable to address this problem, and that should be made public for consultation. And then the examination goes on for 12 months or perhaps 6 extra months if necessary, and then there will be a decision which can be appealed to courts. And the commitments can also be accepted. I think I will skip this. This is just a schematic view of how a case goes on, sort of. I think the text is too small, but if you are really interested, you can contact me. I'll give you the slides. What do we think about this then? Well, it's true, Alessia, that there are some signs that competition in some sectors, there might be problems, for sure. However, in Sweden, we have not seen any convincing arguments that the competition or markups or concentration has been rising, specifically in those sectors which are more or less targeted here. Especially the food sector and banking sector and building sector, for instance. So we don't see any strong economic evidence why this would be necessary. And we also, I think everyone agrees here, probably there is a false connection to inflation. Inflation and price increases have not been because of lack of competition, but because of many other reasons. And the general sentiment, which is quite strong in the business community, is that this leads to uncertainty and unfairness in these sectors. So it's really difficult for business to make good investment decisions when there is the threat or even an ongoing investigation of this kind, which could result in structural remedies. That is very, very difficult and problematic. So this will then lead to a hampering of investments and risk-taking. And also there is a risk for regulatory failure, even though we, in general, have high confidence in the Swedish Competition Authority. That has been sort of taking a bit of a hit, actually, lately, which I will show very soon. And also, finally, we see now the problem of fragmentation, where different jurisdictions are imposing these kind of rules, but they are designed a bit differently, each and every one of them. So it could also be problematic from a business perspective. So just to give this example of regulatory failure, how wrong things can be, the Swedish Competition Authority got a specific assignment from the government relating to inflation and the high increases in food prices that we've had, as many other countries. And the political suspicion was more or less whether the companies are raising prices more than inflation. An important issue for many of the voters, of course. And the outcome from this very extensive study, based on several reports, and they even got extra funding for doing this, is that as the competition authority writes, the grocery players have, to varying degrees and due to market power, been able to increase profit margins by applying oligopolistic pricing strategies towards consumers. So quite strong conclusions there, and really sort of bashing this sector quite hard. But if you look into the basis of this statement, it's based on an increase in gross margins measured in kronor, which is, as you maybe heard yesterday, the currency in Sweden. And that is an absolutely flawed method, I would say, if you consider the fact that when the grocery players are buying their inputs, that is only about 60% of their costs. And if you look at as I said, the gross margin, it only takes into account the input prices and then what you can sell the same products for to the customers. So they totally skip the fact that personnel costs, for instance, have risen quite extensively. There was also a removal of an exemption for employers' tax for young people up to 24 age during this period, and a lot of people working in this sector are quite young, so that increased the costs quite significantly for these actors. And also, of course, electricity, heating, other transport costs and other things. And of course, interest rates on the loans of these companies. Everything increased quite a lot, but that is not being taken into account by the competition authority. So, and if you look at this graph, you can see that the other costs have been sort of following the gross profits more or less linearly. The gap between them is not increasing, at least. And you can see in the bottom there that the operating profit, which I think most would agree is a more reasonable measurement of whether they are sort of increasing their prices more than their costs, they actually went down during this period. So you can see there is a small increase of profits during the pandemic years, maybe because of people shopping in the grocery stores rather than going to restaurants. And then there was a decline during the inflation times. And overall, the profits are quite low in this sector, about 5% or something like that. So really disappointing, to be honest, and a striking example of how things can really go wrong in the hands of a competition authority when they end up wrong in their methods. So, some final words. We think the new competition tool is dangerous and unwarranted. It will lead to more uncertainty and an administrative burden, and we'll see what will happen in the EU level if the new commissioner for competition will revive this or not. It will be interesting to see. Thanks.
Thank you, Stefan. So I don't want to make too much pressure on you, Lars, but we have a good view of the pros and cons.
Yeah.
So on which side will you push the final conclusion of the panel?
Yeah, perhaps first give a rough overview of what's the situation in Germany, because since last summer, 2023, for the first time, the German authority has a tool they have the tool in the German Act Against Restraints of Competition to intervene in the market without having previously established an infringement of any provision. And the rule was discussed a long time ago with the previous government as well. It was never concluded, but finally last year there was an agreement, and it was also inspired by the UK system of the CMA and the market investigations conducted over there. But maybe one step back, because for further background, it's notable that in Germany there are specific tools. So we have the classical measures in competition law, as you explained in the beginning, Patrick, but partly a bit broader, in particular with the topic of abuse of dominance, and also a specific tool with the previous amendment of the law, catching undertakings being of paramount significance across markets, meaning that in particular the big US tech companies were triggered as a target, as a specific tool within the dominance area. Plus, we have in the area of merger control a so-called value of transaction threshold. It was I think, introduced in 2017 and driven by the acquisition of WhatsApp in those days, because there was no turnover generated, we had strict turnover thresholds, and the FCO was, I would guess, not really happy that they weren't allowed to review that case. So that's a bit, we have some rules, some special tools in Germany already. But now, since last year, it's similar to the UK system, a very new tool, a broad tool that requires a sector inquiry and a report thereof to be issued. So to give you a flavor what the FCO does, it's 2 or 3 sector inquiries per year. That's roughly what they do. And they very recently concluded one in the scoring and on online shopping. And currently there are 2 more ongoing in the charging infrastructure for electric vehicles and in mineral oil. And the tool has an impact on all levels, even on merger control. I think it's very similar to the Swedish system, because the authority can ask or require undertakings to report transactions that would normally not fall within the regular thresholds. Very similar to the Swedish one as well. I think the acquirer has to has to meet the regular thresholds in Germany, which means 50 million, 50 domestic turnover, but the target only requires a turnover of 1 million. That usually is 17.5 in Germany, a quite high threshold for the target or the second undertaking involved, which is lowered massively now. So they would not be required to notify all transactions, but a huge amount of them, because the value of transaction threshold, an alternative threshold, would not require any turnover at all, but the value of transaction has to be 400 million euro. So, literally speaking, purchase price, which is not met with every deal, as you could well imagine. Other undertakings that can be caught irrespective of mergers are described in the law as addressees of measures can be companies whose behavior and significance for the market structure significantly contribute to a disruption of competition. So irrespective of any infringement, very broad concept, but the law provides for some examples. For the disruption, for example, it says it's not kind of conclusive. It's only by way of example, so the Federal Cartel Office can also look at other distortions as well, but the most important ones are unilateral supply or buyer power, restrictions on market entry, market exit or capacities, uniform or coordinated conduct, or foreclosure of access to input factors. And criteria to be taken into account are similar to the concept of paramount significance across markets in Germany: financial strength, number, size, turnover of the undertakings, prices, quantities, choice and quality of the products or services, transparency of the goods, contracts and agreements in general. So it's a very, very broad concept and kind of a risk of a lot of being caught if they really want to use that tool. And from a remedy point of view, it is broad as well. The law only provides for some examples, but they are not conclusive as well. So it says, for example, granting of access to data, requirements for the business relationships between undertakings and the markets examined and at different market levels, obligation to establish transparent, non-discriminatory, open norms and standards, prohibition to unilaterally disclose information, and a couple of more. So again, very broad. With this concept, we don't have any specific case law yet, because on the other hand, there are a couple of safeguards that are, at least in Germany, to be regarded as making the tool perhaps less effective. In particular, the other classical measures that we have that are broader in Germany, as explained, are not, or appear unlikely to be sufficient. So it's kind of a ranking. You have to go with the classical measures first. Then companies whose conduct the conduct has to contribute significantly to the functioning of competition. Again, significantly, it's not legally defined, but only in an explanation of the draft bill, it says the disruption has more than just one minor negative effect on competition. Again, very broad again. And, but you have a time limit as well. So the authority needs to show that the competition is deemed continuing, or the malfunctioning of the competition, is deemed continuing over a period of 3 years, already existed and is looking into the future to be deemed likely for another two years. Finally, the Monopoly Commission has to be approached and asked for their view. The Monopoly Commission is an independent body in Germany who can be approached in merger cases for an approval of the ministry. So usually it is irrespective, it is split, the Federal Cartel Office and the Ministry for Economic Affairs. But for approval of ministry, which is a mere political driven instrument in merger control, the Monopoly Commission has to be approached, mainly consisting of economists, lawyers, professors, and doing or providing exhaustive memorandum on the cases. So that is where we are in Germany. We have a risk of having a very broad tool, not really practical experience with that very new broad tool. However, when we look back to the second newest tool in the area of US big tech, the undertakings that are of paramount significance across markets, we see that the Federal Cartel Office is rather self-confident, not to say bullish, and has open proceeding against all big tech GAFAM, and they are even in a stage where some of them were challenged in court. Courts recently agreed with the Federal Cartel Offices, and it's, in my view, a risk that they would use the same approach and use it in a new tool.
Thank you. So, looks a little more complicated than in Mario Draghi's report. Let's assume for a couple of minutes that you are, the three of you, Vice President of the European Commission, and I am Ursula. And instead of deciding by myself as usual, I ask you your opinion. Should we create at EU level a new tool for the DG Comp and the European Commission to use?
Thank you, Patrick, for this question. I want to start by saying that perhaps, as I said before, there is space for further intervention by competition authorities, because we know that there are some circumstances in which there is a lack of competition. And as an economist, I think it is good if such intervention and remedial action are designed by expert authorities as the competition authorities. Now, I'm not familiar with the Swedish inquiries in the food sector, but generally speaking, I think it's good to have experts doing this kind of job. At the same time, I think, in Italy there has been a lot of discussion about this tool, and the Italian community has labeled the tool as superpoteri, superpowers. I think that this expression well summarizes the downsides of this tool. So I wonder whether there is space to limit the tool. So we start from the consideration that there is still space for the competition authorities to intervene, even with new tools, different traditional tools. But maybe if we use the old but still solid guiding principle of balancing the benefits that competition and consumers can get from this intervention and the cost, the administrative burden for private sector, but also for the competition authorities that have limited sources, I think we will reach the same conclusion that has reached back in 2020, so that there is a need to limit the tool. At that time, we decided to limit it to the digital sector, but still I think there is a need to limit such a broad tool. So I hope this answers your question.
Thank you, Teresa. Alessia. I'm not sure that the DMA is really a new, well, it's new, clearly, but it's not something with market investigations. You just have to reach some objective criterion, which is to be an American company, to be a large platform, and then, blam, you take the whole package No more most favored nation clause, no more self-preferencing. There is not really market investigation, but you're right, it exists. So, dear co-commissioners, what do you think?
So, no surprise, I think, from me that I am very skeptical about this tool also at EU level, both on national and EU level. I think what we need on EU level is not more administrative burden, really, for companies. It's rather the opposite. On the other hand, of course, we want more competition. We want more competitive markets because we know that competition drives competitiveness. So, but I think this is done better in other ways, like improving the functionality of the internal market so that we can have more cross-border competition. As was mentioned earlier during this conference, to make it possible to have more mergers in telecom, maybe you need to create a larger market, sort of, a bigger playing field. So that is the way to go, I think. And I know, for instance, in Sweden, we would very much need more competition from companies from other countries, especially in the food sector or in the building sector. But that should be done by changing regulation, making barriers to entry smaller, for instance. So I say no to the tool. Thanks.
Thank you.
Yes, I would agree, I guess. Let's see what Germany does from a mere German perspective. As a German lawyer, I would say I'm fine with Germany practicing it and seeing where this goes. And yes, perhaps also with respect to the DMA and the specific tool in Germany, the paramount significance across markets. Perhaps really something that could be better dealt with on a national level as well first, and then let's see.
So you see why I am never consulting my commissioners, because they cannot agree on anything. So I will decide by myself. And maybe a good idea would be to let national authorities play with different tools, and after, I don't know, 5 years or 10 years, ask some new guy, an Italian guy, of course, to prepare a new report comparing the different features of the different national tools, and maybe taking a decision, even if, of course, that could lead to fragmentation of the EU, which is not necessarily good news for companies. So, do you have any question?
Shall I go first? Okay. Thank you. Mirta Kaplan, I'm the head of Croatian Competition Agency. You would be surprised, but on this one, I totally agree with business. I will tell you why I'm against introducing the new competition tool, because there is no need for one. First of all, we do have market investigation power, which works very well in practice. Although we have much smaller resources than Bundeskartellamt, we also do 2 to 3 sector inquiries per year. And we do food sector inquiries since 2012. So I realized that due to inflation and pressure of the politics, which we all felt, definitely, other competition authorities also started doing it. But we are doing it for a long time, and we always present it to the public, and it's actually very valuable according to the business, especially in retail and wholesale sector. They say it's a very useful source of data. Although, of course, sometimes there are some wrong conclusions also could be drawn, like this year, for instance, when we published for 2023 the results, one of the conclusions was, okay, the prices are very high. It's not because of euro, it's not because of inflation, it's the merchandisers are earning much more than the last 2 years, so please, competition agency, do something about how it prices. I mean, this is something which obviously we cannot do. But that was my first. Second, we do also have structural and behavior remedies. And the third, maybe most important reason, in my view, is the legal certainty. Because if you put it like this, too broad, as we see also example in Germany, I know that my colleague, Mr. Mund, was not at all happy when they got this competence. Exactly because of this reason. We said, yeah, okay, we got it, and now what shall we do with it? How shall we do it? So leaving it broad like that Okay, I think something is wrong in this market, okay, let's just do it. First, we don't have resources to do that. Secondly, for the legal certainty, even if there will be some new competition tool in the future, it should definitely be very well precise. What does it mean? What does it entail? To whom it will apply? And in which way? Thank you.
Thank you. I have a practical question. My name is Mattia Melloni. I'm one of the fourth commissioner of the Luxembourg Competition Authority. So you play the game that you want to be the commissioner, and you have 3 president of a commission and 3 commissioners. And my question is a very practical one. We have to amend Regulation 1/2003. It's on the table since a while. I would like to know what you would do in order to improve this tool, which is an essential one for 101 and 102. We have our own ideas about one of the chapters of Regulation 1/2003, namely the chapter which deals about cooperation between national competition authorities and the commissions. But we would like to hear from you, because you are the commission, and Regulation 1/2003 is about the tools the commission uses in order to enforce 101 and 102. I would like you to tell me, first, what do you think of Regulation 1/2003? Has it worked well up until now? Yes? No? And if no, what you think should be amended? What should the Commission do in order to have a much better legal instrument, legal tool, in order to apply 101 and 102 in a much better way? Thank you.
I think that, again, I will consult my vice presidents.
I was just about to say it's rather the big picture and a question for the commissioner, but it's indeed a very good question. And 1/2003 provides for specific competencies, and which I think should be adjusted to what happened in the last 20 years, right? So I'm not sure how to take that into account, what happened there, and bring it into that regulation, or perhaps do something very new and think about that system more generally.
Generally, when something has not worked for a long time, it's an indication that it will never work. And that something else, unless it's totally useless, okay, so, or something different should appear, because there is also a reason why, when something has not been used or efficiently implemented or enforced. That's my view.
I can.
Of course, sometimes you see that the Commission tries to revive something that has been useless, like in the Illumina Grey case, but you saw that it didn't work at the end. Something which is abandoned or not used should hardly be revived, I think.
I mean, this is out for public consultation right now, and what we do at our offices is that we inform our member companies and on our member organizations, the different sectors, and hopefully they will engage and give us some feedback how they perceive things. And to be honest, I haven't received much feedback, at least not yet. I mean, we haven't sort of finished taking a stand. So, and that usually tells us that, well, things are probably working out quite okay. And in general, I mean, business are in the field of competition really interested in stability, stability and harmonization, more or less. So I think that from a business perspective, at least in Sweden, no major changes are really requested, I think.
Yes.
Hello, Christoph Rapp from Bindergrossing in Vienna. I'm actually thinking, and I want to hear your views on that. If isn't it the tool not the problem, but more who wields it? Because I can see in the British case, of course, all the examples you gave show us very much what can happen if the tool is wielded in the right way. But also one needs to think about the structure of the regulatory system in the UK, where you have sector regulators with competition law powers, and of your 3 examples, 2 were in regulated sectors. So you had the banking part and the airports. And well, the third one is an outlier, because that's a very strange market. But in general, I have the feeling that the UK system is working well for it. And I have the feeling that we in Europe and then also in the member states, we've lost the trust in lawmakers, because most of the things that the CMA actually did are regulatory measures, something that in our democratic state should be done by lawmakers. And well, the concentration issue you can probably tackle with Towercast, even though Patrick says one shouldn't revive stuff that has been dead long ago. But I want to hear your thoughts on this, whether the tool is actually a good one, but the very important thing is whether the competition authorities are the ones who should wield it.
Yeah. Can I start? Yeah. I completely agree. I mean, if you have a tool without the decision-making powers to the competition authority, then you have what we have right now, which is the power to make market investigation and give recommendations for the government and the parliament. And I think that is, in these cases, much more suitable. As you say, it's often about regulating markets and almost designing markets sometimes. And I think that is a huge power that, at least from our perspective, we don't want to give in the hands of sometimes a few people, which can end up really wrong. So I completely agree.
I think there are also good examples of this way of working, a market investigation without any power but with just recommendations, and then governments drawing conclusions. In France, there are several examples, but one was quite spectacular, the opinion of the French competition authority about buses, intercity buses, which was heavily regulated and practically not working in the country, and the government followed the recommendations of the competition authority, and it led to almost the creation of a new market. I think it was it is still a great success, without the need of providing really powers to the competition authority. Maybe it is also the result of some kind of power between brackets, but because in the remote past, the French competition authority only could conduct investigations and issue opinions if somebody was asking for it, mainly the government. But there was a reform authorizing the competition authority to issue a report on anything they wanted. And I think this was a game changer without the need of providing them with power. Another question? So I think it's time to thank our panelists.